Morning, Your Honor. Benson Banger appearing on behalf of the plaintiff, Acme Inc. This is scheduled on plaintiff's motion for default under case number 23-5-973 KCX. As indicated, this is plaintiff's motion for default. The defendant was served in this case more than 20 days ago and has not filed an answer. However, the defendant did send my office some letter. It didn't really dispute anything, just that they were there. As a result of that letter, we have sent a copy of this motion and note for hearing and the proposed judgment to the defendant. The declaration of service of process for the original summons and complaint is on file, as well as a declaration of mailing where we mailed a copy of this motion and notice of hearing. Also on file, you will find a copy of a declaration concerning the defendant not being a service member or otherwise entitled to any relief under the Service Member Civil Relief Act. This is a straightforward collections matter. It is a breach of contract. Acme Inc. provided to the defendant 500 units of their product, which was a widget, as is indicated in the declaration of plaintiff. Those 500 units were not paid, and this occurred approximately 2 years ago. As my client testifies in her written declaration, after the widgets were ordered, the defendant accepted them and about 6 months later attempted to make a complaint that there was some sort of a defect in those products. However, they had had more than enough time to examine the products. The widgets at issue are a very simple product, and whatever defect or defense that might be available has not been affirmatively raised by the defendant. As such, a motion for default is appropriate here. An order of default is appropriate. The order sought and the judgment sought includes prejudgment interest from the date of the breach. It also includes a request for attorney fees. The contract between Acme and the defendant has an attorney fee provision, and so that's appropriate. Although in this matter I am on a contingency basis, I have still approximated what reasonable attorney fees are under the context of this case, the relative difficulties, the straightforward nature of the procedural history. Further attorney fees may be appropriate as the collection process unfolds. I'm happy to answer any questions that Your Honor may have. A copy of the judgment will, of course, be sent to the defendant. Hopefully we'll be able to make some sort of arrangements for payment sometime in the future. Thank you. Okay, as you might have guessed, that was not actually me appearing in court. I do not have a authority to record and put on YouTube copies of recordings of any kind of motions. However, a very common motion that a debt collector like myself will need to do is this type of motion for default. It's incredibly common when a plaintiff creditor files a lawsuit against a defendant that the defendant doesn't really contest the amount sought. In many cases, it's just not worth their money to hire an attorney to do so because they don't have a defense. They just couldn't afford to pay, and that's perfectly understandable, and that might continue to be the problem. But until the plaintiff creditor goes and actually obtains a judgment from a court, it's really just a claim. And there's some good reasons that a creditor needs to move forward, even in the context that they think the debtor might not be able to pay the judgment. One of the biggest is usually a statute of limitations, but another is just they want to try. And they think that the debtor could afford to pay, they just have to be forced to do so. Now, once the judgment's entered, the court doesn't do anything to enforce it, but that gives the creditor, or attorneys like myself that work for creditors, the opportunity to enforce the judgment through mostly writs of garnishment, but sometimes other options as well. Most of the motions for default go pretty similar to how I described it. I will appear in court if I have to provide notice of the motion for default, or I'll simply submit it in writing if there is no notice required for the other side. In fact, in some courts, even if notice is required and you actually are supposed to have a hearing, it's a no oral argument hearing, meaning everything is done just by the writings. They're very straightforward. It is a simple action for any party involved. If you go to the dockets that cover these kind of hearings, you'll usually see several very similar motions happening, and they'll seem very repetitive because they are very repetitive. It's it's kind of the nature of making sure that the judge agrees with the proof that the creditor has and has submitted. And the real difficult part from the legal enforcement standard is going to be after the judgment's entered, doing those writs of garnishment, finding the assets. So, thought I'd make a quick video so that if you, next time you're sitting in court and you're wondering why everything had happened for this motion for default, or if you had hired an attorney, or you yourself are even an attorney that's preparing for a motion for a default, that's kind of what you're going to expect to do, or what you would have seen. What we're looking for in a motion for default in Washington State is proof that service of the initial summons and complaint has been done on the defendant. You're looking to make sure that whatever default judgment is sought at least 20 days after the filing and service on that defendant. The other thing that courts are really going to be paying attention to is making sure that the amount sought in the default judgment matches, at least in kind, the amount that's referenced in the complaint. Sometimes the amounts can be a little bit different, and that's because in your complaint the full attorney fees and full costs won't be known, and also because there might be additional there might be additional interests that have arisen since the filing. And you don't have to do it right at 20 days. Some attorneys and some law firms might even intentionally recommend waiting a little bit longer. And so once you've got that kind of basic stuff down, there's also a federal law that protects service members, people in the military, and that action, so any kind of an action where you're seeking to get a default judgment against anyone, you need to make some kind of a showing that that person being defaulted is not protected by the act. The easiest way to do that in most circumstances is to contact the Department of Defense through their online website that they maintain, and you can search by someone's name and birthday, or name and social security number, to determine whether or not they're active duty as of a particular date. If they are active duty, you can't obtain default, and the court will appoint an attorney to look into the matter. That said, just because someone is in the military doesn't mean they're not subject to default judgments, just that their lack of appearance cannot be a result of their military service. It's a pretty fair accommodation that the U.S. Congress has put in place. Once the judgment is entered, there's a slight waiting period before you can enforce the judgment. It's either going to be 10 days or 30 days in Washington State. Other states might have different rules. I don't practice there. Look forward to making any other videos of a similar nature to go over other types of motions, their merits, and similar. If you need any help, please contact our office. Thank you. Have a good day.